Okay, so this is 205.17, permanency hearings for child in foster care placed directly with relatives or other suitable persons and children freed for adoption. A. This section shall govern all permanency hearings conducted pursuant to 10-A Family Court Act. B. Scheduling for dates certain deadlines for submitting reports. 1. The first court order remanding a child into foster care or into direct placement with a relative or other suitable person in a proceeding pursuant to 10 or approving a voluntary placement instrument pursuant to 358-A SSL must contain a date certain for the initial permanency hearing pursuant to 10-A Family Court Act, which must not be later than 8 months from the date of removal from the home. If the child has a sibling removed from the home whose hearing is scheduled before this court, the date certain shall be the same as the date certain as the sibling, unless the sibling was removed on a 7 or 3 or they have been freed for adoption. 2. A permanency hearing with respect to a child who has been freed for adoption shall be scheduled for a date certain not more than 30 days after the earlier of the family court's oral announcement of its decision or the signing and filing of its decision freeing the child. 3. In any case where the court made a determination that reasonable efforts to reunify the child with their parents is not required, a permanency hearing must be scheduled for a date certain within 30 days of the determination, and the originally scheduled date, which is like the one they originally picked with the 8 months, that's going to be canceled. In such a case, a permanency hearing report shall be transmitted on an expedited basis. The report is transmitted to the parties and counsel and the child's attorney, as directed by the court. 4. Each permanency hearing order must contain a date certain for the next permanency hearing, which shall be not more than 6 months following the completion of the permanency hearing, except with respect to a child who's freed for adoption. If the sibling has a permanency hearing scheduled, they are supposed to be on the same day, unless the sibling was removed on a JD or PINS or the sibling's been freed. 5. If the child has been adopted or has been the subject of a final order of discharge or custody or guardianship by the scheduled date, the hearing shall be canceled, and the petitioner shall promptly so notify the court, all parties and their attorneys, including child's attorney, as well as the individuals required to be notified of the hearing, pursuant to 1089. C. Required notice and transmittal of reports, except in cases involving children free for adoption. In addition to sending the report and accompanying papers to the respondent parents' last known address and the attorneys not less than 14 days in advance of the permanency hearing date, the petitioner shall make reasonable efforts to provide actual notice of the hearing to the parents through any available means, including but not limited to casework, service, and visiting contacts. Additionally, not less than 14 days in advance of the hearing date, the petitioner shall send a notice of permanency hearing and the report and accompanying documents to the non-respondent parents, the foster parent or parents caring for child, and each of whom shall be a party, and to the child's attorney. The petitioner shall also send the notice and report to a pre-adopted parent or relative providing care for child, and they also must send a notice, but not the report, to former foster parents who cared for the child in excess of 1 year, unless the court dispense with such notice. Now, it just says in excess of 1 year. It doesn't say immediately preceding the petition or 1 consecutive year. It just says in excess of 1 year, unless the court dispense with notice. Those persons get an opportunity to be heard, but they shall not be considered parties, and their failures to appear shall not constitute cause to delay the hearing. As provided in subdivision D, petitioners shall submit on or before the return date the documentation of the notice or notices given to the respondent, the non-respondent parents, their attorneys, child's attorney, any present or former foster parent, pre-adoptive parent, or relative. So there's 7 individuals or 7 things that have to get it. 1 is the respondent, 2, non-respondent parent, 3, their attorneys, 4, child's attorney, 5, any present or former foster parent, and that was 6, any pre-adoptive parent, or 7, any pre-adoptive relative. D, required papers. 1, sworn permanency report. Shall be on the form officially promulgated by the fucking chief administrator and shall contain all information required by 1089. 2, the permanency report shall be accompanied by additional documents, including school cards, photographs, clinical evaluations, and prior orders. 3, the copy of the report submitted to the family court must be sworn and must be accompanied by a list of all persons and addresses to whom the report and or notice of the hearing were sent, and must be accompanied by a list of all persons and addresses to whom the report and or notice of the hearing were sent, except as otherwise provided by the family court. The list containing the addresses shall be kept confidential and shall not be a part of the court record that may be subject to disclosure pursuant to 205.5 of this title. Copies of the hearing report required to be sent to the parties, including the attorneys, not less than 14 days, need not be sworn so long as the verification accompanying the family court's copy attests to the fact that the copies were identical in all other respects to the court's sworn copy. In any permanency hearing, the child shall be represented by an attorney, and the family court shall consider the child's position regarding the permanency plan. Now, it says that they shall consider the position, but it does not have an age. Usually it'll say, like, oh, if the person's over 14 or 10 or over, they have the right to, say something. This just says they shall consider the child's position. Consider the child's position.